Good day and welcome to this week's episode of Strictly Legal on WESN Content Capital. I am your host, Rondell Donawa. Once again, I'm happy to bring the law and you. Today is the Thursday after Easter, and I hope that you had a great Easter weekend and you are keeping safe and sanitized. Of course, you can stream us on WESN CC as well as all social media platform, our podcast Strictly Legal with Rondell Donawa. Today, we are going to speak about firearm usage and the law in terms of how can you apply for firearm user's license, what is the law regarding firearm use, whether or not citizens in Trinidad and Tobago have a right, a constitutional right, as we say, to bear arms. And I have a very special guest with me in studio today. His name is Mr. Cedric Neptune, attorney at law, who has over 20 years experience. He's a senior partner in law firm of Neptune and Neptune Attorneys at Law in San Fernando. He practices family law, property law, non-contentious, probate law, immigration, criminal, and a plethora of laws. He was a former Trinidad and Tobago Police Service officer, where he worked in several different branches and sections, including the Guard and Emergency Branch and the Homicide Bureau of Investigations. He also lectured in training programs at the TTPS, the Port Authority of Trinidad and Tobago, the Board of Inland Revenue. He's a holder of an Executive Master's in Business Administration from the Arthur Lockjack Graduate School of Business. And he served as a representative of the Trinidad and Tobago Police Service on the Cabinet-appointed committee to oversee the implementation of the amendments of the Firearms Act in Trinidad and Tobago in 2006. Mr. Neptune is currently the Inspector of Prisons, so he's a very important person with his bodyguards outside. No, I'm just joking. So without further ado, I'd like to welcome Mr. Neptune to the set. Good morning.
Good morning, Mr. Donawa.
How are you doing?
I'm fine.
Well, I mean, it's been a while, but you're here. You're here where many greats have sat.
Yes. And hope I could do justice to it.
I'm sure you would. So we're speaking about firearms, right? Mm-hmm. And the law relating to the usage of firearms in that context. Mm-hmm. Now, I mean, I know it's an obvious question, an obvious answer to this question, but of course, many of citizens may ask: do citizens have a right to, as we quote, constitutionally bear arms, as is the case in the United States?
Well, not in Trinidad and Tobago. There is no constitutional right to bear arms. There is no constitutional right to be issued with a firearm user's license as well. The only way you can lawfully use a firearm, say for except that you are a member of the protective services or customs included and so on, the only way you can lawfully use a firearm in Trinidad and Tobago is if you are issued with a firearm user's license by the Commissioner of Police. The Commissioner of Police is the only person in Trinidad and Tobago authorized to issue firearm user's license to citizens of Trinidad and Tobago. So unless you have a license, either as a firearm user substantively or as a firearm user employee certificate, meaning like persons who work with the security companies and so on, unless you have that kind of approval, you are not entitled to use a firearm in Trinidad and Tobago. Say for example, I say, you're protective services, member of the cadets doing drills, member of the Forensic Science Center testing firearms and so on. Those persons are exempted under the legislation, but the use and carry firearms in Trinidad and Tobago, generally you need a license. Now
we've seen that there has been a whole hullabaloo, as we call it, about the fact that there has not been equitable distribution of a license, or rather there has been a lot of corruption, let's put it that way, in the service. Now, if you can walk us through before, how does one acquire in terms of applying, or what are the steps or procedure that one has to take in consideration when applying for a firearm user's license?
Okay, well, if you are desirous of applying for a firearm user's license in Trinidad and Tobago, you must complete the prescribed form. The prescribed form is in the legislation, and the form is addressed to the Commissioner of Police. The Commissioner of Police, upon a person seeking to obtain a firearm user's license, will be required to issue a provisional permit for the applicant. Once they issue a provisional permit, and the provisional permit will be before it is issued, the premises, certainly you are required to provide certain documents. So you are required to provide a certificate of character, good character. You are required to provide 2 photographs, any other documents that the Commissioner of Police prescribe, which will include information as to where you live and so on. And if you are residing with a spouse or any other adults in the house, the investigation will require that those persons gives basically statements indicating a non-objection, so to speak, and as well as any other requirement, whether it's psychometric testing review, medicals, as required by the commissioner. Once the commissioner is satisfied that those documents are in order and there are no convictions or no pending matters for criminal conduct before the courts, the commissioner will issue a provisional permit once they feel that your application is justified, because the commissioner has to determine that it is justified.
And when you say a provisional permit, is there a time stamp on that particular
yes,
permit?
Yes, but the provisional permit is valid for 2 months, during which period of time what the permit does, it gives you authorization to train in the use of a firearm. So you're permitted to discharge a firearm on specified areas in terms of a range under the supervision of the holder of a firearm user's license. So that permit allows you, so to speak, to train. Once you have completed the training and the instructor is satisfied that you are competent to manage and to use a firearm, the instructor issues what we call a certificate of competence. And it's only upon the issuing of the certificate of competence then the commissioner can fully consider whether or not to grant you a firearm user's license. So it is not automatic. It is not because you have a provisional permit you are going to get a license. That is not how it works. The commissioner still has to assess everything in totality, and once the commissioner is satisfied that the application is justified, whether it's for protection, personal protection, whether it's for hunting purposes in terms of shotguns and so on, once the commissioner is satisfied that that is justified, it's only then the commissioner of police will issue you a firearm user's license, which will authorize you to purchase and own a firearm in Trinidad and Tobago.
And these persons who give the all clear in terms of certifying you as trained to the specification, do they have to be registered? They
have to be registered. The firearm instructors have to be registered. Usually, those firearm instructors are persons who are either firearm dealers or persons who have firearm ranges in Trinidad and Tobago, or persons who are otherwise certified, because there are persons who don't have a dealer's license and who don't own a range, but they are certified because they have done the necessary training. Either they were members of the Trinidad and Tobago Defense Force, or they were members of the Trinidad and Tobago Police Service. You find a lot of the instructors are either former members or even sometimes current members of these protective agencies. And once they are qualified, they are registered with the Commissioner of Police, and then the Commissioner of Police could accept their quote-unquote certification of the applicant.
And in terms of the how many is it firearm that you can possess? Is it that is there a cap in terms of how many licenses that you can possess, or how does it work in terms of if you are to possess more than one firearm?
Well, you will have one firearm user's license, but the firearm user's license could have a variation. So for instance, you may have a person who has a pistol, which is ideally for personal protection, or that person may have a pistol for the purposes of target shooting and so on, because they may be a member of a rifle club, they may be engaging in competition, as the case may be. But you can still also have a variation of that license, which will give you a shotgun, which is primarily used for hunting purposes. There are persons who have shotguns who are probably not hunters, but generally when somebody applies for a shotgun, over the years that I was in the system, generally it's for hunting purposes. So that there's no specific caps on firearm, but I mean, the reality is the practice of persons having several firearms, 5 and 6 firearms or 4 and 5 firearms, it may have happened in the distant past, but it's certainly something of recent vintage, as far as my memory serves me.
Yes, because we would have seen that the former commissioner would have boasted that he would have approved many persons with more than one firearm, and that has caused a lot of public
disquiet.
Disquiet in that sense. Now, in terms of persons who misuse their licensed firearm, what are the consequences or penalties relating to that, or what circumstances come with someone?
Your firearm user's license is to use your firearm lawfully. I mean, I say lawfully if it's for hunting purposes, for hunting. If it's to protection of yourself, if your life is in imminent danger, your firearm is for that purposes. If it is you go outside the legal framework, so to speak, or you use your firearm to commit a robbery or to threaten somebody, then you are subject to the same laws as illegal firearm holder, so to speak, would be subject to. So your license allows you to operate within the legal framework, lawful protection of yourself, lawful protection of other persons in terms of your family, property, as the case may be, but certainly not for any criminal offense to unlawfully threaten people or to relieve people of their property, what we call robberies and so on. Once you go outside that, you are treated just as if the firearm itself was not legal.
And therefore, you is it that it's a temporary suspension, or they remove, you take away your license?
Right.
Absolutely.
Well, the Commissioner of Police, I believe, under Section 21, or under the legislation, I believe it's Section 21, can suspend a firearm user's license, the holder of a license. So I believe there are allegations of that nature made against any individual, then the Commissioner certainly has the power to suspend your license and seize your firearm until the determination of those matters. And if you feel aggrieved in any way, or you feel that the Commissioner may have acted unlawfully, you certainly have recourse to the courts to try and ventilate that particular issue. But the Commissioner, I would think, would be well within his rights if serious allegation of improper conduct is made against any holder of a firearm user's license to at least suspend that license and confiscate that firearm until the determination of the matter.
Now we've had a recent occurrence where there has been a double murder, suicide, which was in Central, and whereby one member of the protective service would have shot his wife and himself. Now, what is happening is that a lot of persons are commenting that there was a situation, I think 2 years ago, where the same individual would have accidentally shot himself. And persons were asking why is it at that time the firearm wasn't taken away, quote unquote, from him. Is that enough grounds for a firearm to be, for your license to be suspended and your device to be taken away?
Well, I don't have all the facts on that.
Yes.
So let me seek to comment in a general sense.
Certainly.
Now, in that particular incident, I'm aware of the incident of which you speak. Now, certainly once a firearm is discharged, an investigation must take place. If it's involving a police officer, an officer of a first division officer, that is assistant superintendent and above, will conduct an investigation. General member of the public, there would be an investigation. So an investigation, I would think I'll be surprised if an investigation wasn't conducted. Once the investigation is conducted, then a determination has to be made whether or not it was really an accident, or whether or not there was something, as my mother used to say, something in the mortar more than the pestle.
Yes.
Right? Now, once the investigation has been completed and the powers that be, they are satisfied that it was an accident, I could see no lawful reason to confiscate the firearm or to suspend the license. If, however, other factors presented that suggested that it perhaps may not have been an accident or there was something untoward, then surely there would have been a duty to confiscate the firearm. As far as that particular incident is concerned, I'm not certain whether the investigation was conducted. Like I say, I'll be surprised if it wasn't, but I'm not sure if it was conducted and what the results were, and whether the results dictated that the firearm license be suspended and the weapon confiscated.
But in a general sense, it has to be investigated first, because I mean, at least one comment I was looking at is that, well, you are officer of the protective service, therefore there's a higher degree of attention and care when operating your device, your firearm. Sorry, and is it that the standard that is used when they're investigating persons, particularly in the protective service?
Yeah, well, I mean, as I said, to whom much is given, much is expected. So certainly you would expect a certain level of competence by all firearm users, license holders. You would expect a certain level of competence. But surely, based on the fact that in addition to someone having a firearm user's license, if you're a member of the protective services and you have use of your firearm on a daily basis, you will also, I would suspect, even before you get your, what we call FUL, that you are using the government firearms or the firearm issued by your particular agency, whether it's police, defense force, etc., on a daily basis. there's also a higher level of training, particularly if you're in a specialist section. So you get more training than the average citizen. So one would expect a higher degree of, I would say, efficiency and competency in the use of firearms. So when you are investigating any allegation of a discharge of a firearm by a member of the protective services, it's certainly through those lenses that you will be looking at, because you are looking at this person who is not, as we say, ordinary, has additional skills, has been exposed to additional training, and so on. So certainly that would come to bear on your investigations, but it certainly doesn't detract from the fact that sometimes mistakes happen.
And let's turn to now the issue of corrupt practices, particularly in light of there being recently concluded, I'm not sure if it's concluded as yet, but investigation in terms of the whole operationalization of the firearms unit. And of course, in a leak report, there was certain assertions that members of the protective service or the department, civilians, had powers that they should not have had when it comes to granting, or when it comes to fast tracking your application, allegations of bribe, etc. And there are a lot of citizens who are complaining right now that, listen, what is happening? We have but not a right, but we want to protect ourselves because of crime. What is your take on that particular investigation, in light of the fact that now it's unearthed that there has been a lot of corruption in that department?
All right. Well, I mean, certainly there have been allegations of corruption. No one has been placed before the court as yet. Based on, I mean, it is public knowledge that an audit is ongoing in the department, and certainly an audit, by definition, will drill down into the issue of firearms and these recipients and these circumstances, because every application, or every applicant rather, would have a file, and the file is supposed to contain certain things in terms of, from the provisional permit, the relevant documentation, and so on. And they would certainly look at the date of application and the processes to get to the point of the issue of firearms. So those investigations will certainly take their course, and whatever the investigations reveal, then certainly if the investigation reveals improper conduct, then that has its place too in terms of the courts, and the police will do what they have to do as far as that is concerned. But there's certainly, as you say, there have been several allegations of corrupt practices.
I'm trying to be very diplomatic with it.
And they remain allegations until they have be resolved. But in the interim, there are persons, as you say, who have applications pending before the commissioner,
and for years, and we have seen where, or even, people talk, and then some people will be like, well, I got my user's license in 2 months or in a month, and therefore that, persons who follows the law and don't know anybody, because, in our society, or at least if there's a saying, you have to know somebody, or somebody have to know you, right? And it seems as though, of course, until proven otherwise, that was the course of action in the unit.
Well, I have heard some of the rumors. I've heard about persons who claim to have gotten the fire, as they put it, in record time. I don't have the facts in terms of specific dates and so on, but there have been those allegations. And what that does really is that it creates some level of unease among persons who have application pending for a very long time, because I would suspect the proper thing is that if you have a firearm application for a firearm user's license inside, then the commissioner should take a decision. Either they're giving you it or they're not giving you it. If they're granting the license, then there are no issues. If they are not granting the license, then they should notify you, so then you can adopt the other course, which is an appeal to the Firearm Appeal Board, because the legislation does make provision. If somebody's refused a firearm user's license to appeal, and
that's an active board.
But the board is, I know it was active recently. I'm not certain whether it is active at present, but it's a 3-member board, usually appointed by the president. The chairman is usually an attorney of, I think, 10 years practice or more. And once you apply for a firearm, and you are refused, you can make an application before the board to review that refusal. And once the board is satisfied that the firearm should be granted, then the board could actually direct the commissioner to issue you a firearm license on such terms and conditions that the board thinks fit. So certainly if you have an application before the I'll just use the term loosely, on the death of the commissioner, then it falls on the commissioner to make a decision one way or the other. Either they grant you the license, and I say no issue arises to grant you the license, and if they are not granting you the license, to at least indicate to you that you have not been granted the license, so you would know what steps you can take if you feel that your position is so fortified and your application is justified.
And let's turn to now illegal firearms. Of course, any firearm that you don't have a license, that you have a license to carry is illegal. Now there has been several amendments to the Firearms Act. I mean, I know more recently there was an amendment in terms of, and you can correct me, whether or not one has a right to bail if they are held with a firearm. I don't know if it's more than once or twice, but could you just could you just clarify that point in terms of what the legislation is currently?
Right. So if you have your, there's presumption of innocence, but surely if you are charged with a firearm and you have pending firearm matter before the court, and then you are charged with a subsequent, the court has a discretion to grant you bail or not, and oftentimes the court would not grant you bail while you have a second pending firearm matter or firearm-related matters before the court, and the court is well written, it's right, the prosecution, whether it's the police officer acting on behalf of the state or the state council in terms of funding the DPP office, would be well within their right to object to bail if you have pending firearm matters and you are brought before the court with other firearm matters. But the legislation that the Sunset Clause set on actually prohibited the grant of bail for I think it was 120 days. So the court did not have a discretion. But the courts, even in the absence of that particular, I would say, rigid piece of legislation, the court has been engaged in, I would say, a fairly decent balancing exercise in terms of the grant of bail with persons with pending firearms matters as opposed to persons who are first-time offenders. The court has been exercising that discretion from my experience in practicing the criminal court in a fairly even-handed manner thus far.
And in terms of the consequences, or sorry, not the consequences, but the penalties, if found guilty for possession of firearm, is it based on the type of firearm? What sort of discretion that the court uses? Well,
the court, if somebody is found guilty of the possession of firearm, the court engages in a sentencing exercise. The court sentence based on whether the individual before the court. And what do I mean by that? There may be a situation where somebody comes before the court, this is their first time offense, the firearm may be unloaded, the firearm may have been found in their private premises. The court looks at all those factors. So some of those factors will impact on the court's determination on what is a fair and reasonable tariff, as we will say, or penalty to impose. However, there may be aggravating factors which the court is duty-bound to take into consideration as well. For instance, the person may be a repeat offender. The firearm may have been used in the commission of an offense. The firearm may have been used in a public place. The firearm may have been discharged with children around, with many persons around. So the court looks at all those aggravating factors in determining whether or not to prescribe whether you say a non-custodial sentence or a short custodial sentence or a longer custodial sentence. So because the court looks at the prevalence of the offense, in terms of the need to deter persons and so on. And the court looks at the totality, and the court is expected to look at the totality of the circumstances before it in terms of the individual and the facts to determine what is a fair and reasonable punishment as far as that particular individual or individuals are concerned.
And in your, in your experience, because you do a lot of criminal type matters as well, how does the, is the Firearm Act, is the amendment to that Firearm Act really a deterrent to crime? Because, I know the government has tried so many different legislations to deter persons from committing crime by enforcing this non-bailable type offenses, but is it working?
Well, if the issue of a non-bailable offense, so to speak, for a firearm offense, in my mind, the jury is still out as to whether or not that by itself, and I would venture to go out on a limb to say that by itself, make it a firearm offense, non-bailable, by itself would not solve crime. And we have to be careful too in terms of striking the balance, in terms of taking away from the court the discretion to grant bail totally. A judicial officer should be trained enough to look and assess a situation and determine whether to grant bail or not, as the case may be. Because the reality is, and the facts remain, not everybody who is brought before the court by a police officer is guilty of an offense. Those are the facts. Whether you want to accept it or not, the fact of the matter is there have been many instances which have been pronounced on by the court, both in terms of matters before the criminal division and matters before the civil division, where citizens have been wrongfully charged. And I shouldn't say wrongfully, maliciously charged,
yes, indeed.
by police officers and brought before the court. So if you prescribe a situation where you literally tie the hands of a judicial officer and say that bail cannot be granted, to me, I don't think it's the best approach. It should be in the purview of the judicial officer to look at the circumstances, look at the facts of the matter, and determine whether in this instance I would grant bail as opposed to not granting bail in another instance.
I think the public also needs to be sensitized in terms of the presumption of innocence as well. Also, the fact that I think because murders are now, I mean, it's almost a way of life. So, this is why the public feel as though one should not be granted bail, but at the end of the day, there's due process in the law.
And I think that is the essence, one of the considerations as far as the whole Court of Appeal decision on the grant of murder, and what the Court of Appeal basically saying is that don't remove it from the judicial officer, give the judicial officer the opportunity to assess this, and don't tie the hands of the judicial officer. Let the judicial officer, whether it's a master or a judge sitting in chambers, give them that opportunity to look at the facts, present it properly before the court, and determine whether or not bail should be granted, as the case may be. Because, I mean, yes, there are repeat offenders, we accept that, and that is not isolated to Trinidad and Tobago. There are repeat offenders, but I say surely you don't want a situation where a judicial officer has no discretion to grant bail, because even the sunset clause provision that existed before, where
let me just say sunset clause, just for
okay, sunset clause meant that they had a situation where the judicial officer could not have granted bail. Once you have charged with one offense of firearm relating to firearm, and you are charged with a second offense, the judicial officer could not grant you bail for 120 days. But that was only valid for a particular period. So after the expiration, I think was of 2 years, it was not renewed, it wasn't supported in the parliament, and so that's why they say the sunset clause, the sunset on that legislation is no longer applicable. But in a situation where you have persons charged before the court, you want the judicial officer, as I said, to be able to assess the matter properly and determine whether or not to grant this individual bail. And I believe that is how it should be, because the judicial officer function, as we say in local parlance, let them fellas do their work.
Indeed, let them do their work. As Cedric, we are out of time with this, and we appreciate that you coming on set to just give an overview clearly in terms of one firearm and also the law relating to its usage as well. So thank you so much for gracing us, Mr. Neptune.
You're welcome. It was good to be here.
Indeed. It's a wrap, guys. You have been watching Strictly Legal on WESN Content Capital. I'm your host, Rondell Donawa. Once again, see you next time. Be safe always. God bless.